So in contract, we're starting to talk about a different topic. Previously, up to this point, we focused on how contract formation works, interpreting, and then also when you don't want to enforce a contract. Now we're going to be focusing on when a person does not perform according to their promise, why they may be justified for that non-performance. In this episode specifically, we're going to be talking about mistakes. Other reasons why a party may not perform that we'll talk about in future episodes are going to be changed circumstances, and then also any contractual modifications that may be made. So that's going to be the focus for the next few episodes, including this episode. As far as mistakes go, let's talk about the restatement 2D of contracts, sections 151 through 154. 151 defines what a mistake is. 152 says what happens, the difference between a bilateral mistake, and 153 a unilateral mistake. And then 154 says which party is going to bear the risk of the mistake. So 151, what's the definition of a mistake? Well, a mistake is a belief that is not in accordance with the facts. So for example, you believe that this iPhone is an Android, and it turns out that it's not an Android, it's an iPhone, but you believed it was an Android, and so ultimately it was a mistake. Contractual mistakes typically occur when you believe that you were agreeing for one thing and you ended up agreeing for another. It's important to note that this mistake related to this fact needs to occur at the formation of the contract. And it's also important to note that mistake doesn't apply to aesthetics. This is all just a matter of objective understanding of what a mistake may be. A bilateral mistake is when a contract has a basic assumption as to a material effect. And if that's the case, then it's going to be avoidable unless if there is a party who ends up bearing the risk of the mistake, and that's going to be defined in section 154. A unilateral mistake has the same elements as a bilateral mistake, but enforcement would also be unconscionable, or the other party had a reason to know of the mistake, or that they caused the mistake. So we're given a couple of examples of where a mistake may justify non-performance. And ultimately what that means is we don't want to, it's not a breach if a mistake was made. And ultimately a contract is going to be rescinded if, first, the party made a mistake about a basic assumption leading to the development of the contract. Second, the mistake has an effect on the performance of the party that negatively affects the mistaken party. Third, the mistaken party does not bear the risk of the mistake. And to know if they're going to bear the risk of the mistake, there's three ways that can happen. First, the contract is going to say who bears the risk. Second, the party that is aware. The party that is aware that the other party doesn't know the facts, but they do assume that their knowledge is sufficient, that person's going to bear the risk. And then third, the court may also appoint the risk to the mistaken party. And finally, the final element of a contract being rescinded based off a mistake is going to be if enforcing the contract would be unconscionable. So those are the elements of mistake, how they apply, how they work, what a mistake is, and why a contract may be rescinded because of a mistake. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.